Well, again, thank you so much for coming to this joint TechFreedom International Center for Law and Economics event. I'm Berin Szoka of TechFreedom, my colleague Jeff Manne of the International Center of Law and Economics, and I have a distinguished panel here today. As always, when we do these events, we try to present both sides. We just had, as you heard, Commissioner Pai and Commissioner O'Reilly to present their views, and Commissioner McDowell before that. So you heard one side of the debate, and now you're going to hear from people on the other side of the debate. Markham Erickson has represented as a lawyer in private practice, the Open Internet Coalition, Netflix, other companies that have been on the other side of this debate. And of course, Michael Calabrese, many of you may know from the America Foundation, has been involved in these debates for a long time. We're here to defend, I'm sure, the FCC in all respects, in every detail. And then I'm very happy to have my former colleague, Barbara Esbin, who was with me at the Progress and Freedom Foundation for several years. Before that was at the FCC, veteran communications lawyer, and now represents small cable companies, including the American Cable Association at the law firm of Cinnamon and Mueller. And so with that said, we'll just get into it. So we just heard from Commissioner Pai and Commissioner O'Reilly. And I'd just love to hear from Markham and Michael. What were your reactions? Are they on to something? Let's start with process. Okay. Let's start with process. Do you think that this was a good process, how this worked? Was this the most open, transparent, democratic, rigorous rulemaking that the FCC has ever had, as the chairman kept saying yesterday? Or could it have been done better?
I suppose it can always be done better, but I can't remember one that's been more, open or, thoroughly hashed out than this. I mean, I think part of the misconception here is people jump in at the end of the process. In other words, this followed just the standard FCC process, which is notice and comment, but it did it almost on steroids with lots of workshops, town hall meetings, obviously tons of public comments, and it went on a long time, right? So we've been 7 months or more into this. And then at the very end, I think some people are asking, well, this should all be done differently than the commission has ever done things in the last 20 years, and it's a little late in the game to change the rules. Draft orders are never released to the public. It's much more like akin to a judicial proceeding, where things are changing right up. In fact, Kevin Martin was famous probably for, rewriting some orders on the morning of the meeting. Mm-hmm. So things are never kind of made public until they're voted. I mean, it wouldn't be bad to change that process, but we have to do that in advance, not the week before the meeting.
Well, please.
I'd say is, we need to have a long-term perspective here, and this issue and the passion it elicits never ceases to amaze me. But it does. We're talking about a decade of either litigation or regulatory proceedings. A very robust docket when you look at it that way. And the initial decision under the Powell FCC that got us here was itself controversial. It was challenged. It went to the Ninth Circuit. The Ninth Circuit overturned the commission. The Ninth Circuit refused to take the case en banc, and then that was overturned by the Supreme Court.
You're referring to the initial classification of
the initial
under Title I.
That's right, the initial deregulatory approach. So I think this issue has always elicited a lot of controversy legally. It's always been complicated. It certainly was then when you had a Ninth Circuit reversing the FCC and then the Supreme Court reversing the Ninth Circuit. And since that time, the FCC has essentially struggled to try to figure out how to operate in this space post-Brand X.
Barbara?
Well, I have two observations. One is I believe the FCC has struggled with how to operate in this space because the statute does not explicitly give it jurisdiction to regulate Internet services. And that's given rise to years of problems, and we're now in round 3 of how that's worked out. The other observation is about the process. I used to tell people rulemakings are a lot like childbirth, about 9 months from conception to delivery. But those are the easy rulemakings. Difficult rulemakings like this one can take a year or more. That this went out in 7 months is quite remarkable. And there is a process, an old process, for putting a tentative decision out for further public notice and comment, and that was used in Computer 2 in the early 70s. There was a tentative decision, and so it's not that it's completely unheard of to put in a proposed order out for further public comment. It's just that it hasn't been done in a long time.
Well, and back in 2007, as we mentioned before, when Senator Obama objected, Kevin Martin did put out and for another round of public comment the changes to media ownership rules. So that was a major controversial decision. The FCC responded. They didn't do that here.
But look, but here to me, the biggest process problem really is that you have, for example, Wheeler yesterday in his statement saying today's open internet order is a shining example of American democracy at work. Now, I understand the importance of public comment in FCC decision making for a long time, but it is, after all, an expert agency that is supposed to be, we think, sort of justifying its existence because it has a particular ability to collect, assess, and decide what the right response is to highly specific technical sort of information. What I would say about the idea of, for example, opening up the docket to more comment is, from what I can tell from the way the Chairman Wheeler would have responded to that, it wouldn't have mattered whether any of that was actually analytical, rigorous material that contradicted the other side. There's actually an enormous amount of that in the docket, and yet he says, we listened, we learned, and we adjusted our approach based on the public record. I've seen the public record, and the public record, I know because I contributed thousands of pages to it. I know that it contains an enormous amount of information that contradicts the view. But if you listen to Chairman Wheeler, it sounds a lot like, well, we got 4 million comments, as we know, not nearly all of them on one side, and that was enough to sway us. And that doesn't sound to me like what the FCC should be doing.
Well, that's, if I can make a comment, which is, there's an enormous amount of information and data on both sides.
On both sides, of course.
That completely contradict each other. But I think from the chairman's perspective, what you just said is a bit unfair because certainly from his perspective and even from ours to a degree, he began with a proposal, back in May of last year, right? A proposal under a commercial reasonableness standard,
right,
using 706's authority, and there was a whole evolution, that went on based on what was on the record, including the president's statement. Unlike members of Congress, he had to file an ex parte, and so that the chairman himself evolved apparently from commercial reasonableness under 706 to a sender side classification theory to Title II, now to a very, very different type of Title II, and jettisoning even at the last minute the sender side classification.
Right, but what concerns me is that it sounds like, from the way he's talked about it and the way others have talked about it, what pushed him in that direction was indeed comments from the president, not an expert commenter by any stretch, and the millions of often auto-generated, very short and not particularly or in any way rigorous comments from many commenters who said, this is terrible, you really need to go to Title II. But I know that what also came in during that period were thousands, if not tens, if not hundreds of thousands of pages actually analyzing the problems of going farther. And that's not to say that I don't know that he didn't read and assess that material, but he hasn't given us any indication that he has. And when he points to what changed, what he learned in the interim between his initial proposal and today, it's that 4 million, he says, commenters said, we want Title II, and so did the president.
But I think, at least from my perspective as a practitioner in this space, the key issue for Chairman Wheeler will be whether he explains it well enough in the docket when
Sure.
he's faced with an appellate court that's reviewing that. And again, it kind of gets me to my earlier point that this rulemaking itself is not in a vacuum, right? It's not a one-off. It's actually a remand, essentially, from the Verizon case, which itself was a reaction to the Comcast case before that. So there is a lot that's been developed both in the courts and in the docket. And I agree, he's going to have to explain why he went to Title II and do that in a way that is acceptable by the court. But we do have 3 courts of higher two appellate courts and the Supreme Court that have said Title II is open to you. So it's not without a great deal of prior work that he's operating.
Well, I
sounding like
think
Barbara.
that's an interpretation of the Rein
I was going to say,
decision.
yeah, exactly.
Not everyone is in agreement that the court invited the commission to reclassify for the sole purpose of getting around the problem of regulating a non-common carrier as a common carrier under Title II. And we can debate it endlessly.
Well, and we will.
That's just my observation.
Well, so before we get into that, because that is the big next question, let me just read you what Senator Obama said back in 2007. So again, we've been through media ownership once before, went through the courts, and went back to the FCC. So it was on remand. The FCC had only lost once. And Kevin Martin had 10 studies produced on the issue. So it wasn't just a docket. There was a huge docket, and there were 10 studies. And he said, well, that's not enough. He said, I believe that both the proposed timeline and process are irresponsible. Although such a proposal may pass the muster of a federal court, Congress and the public have the right to review any specific proposal and decide whether or not it constitutes sound policy. And the Commission has the responsibility to defend any new proposal in public discourse and debate. And that's why Kevin Martin put that out again for additional comment. And then by doing that, he avoided any of the problems that were discussed with the fireside chat about whether the FCC had adequately noticed what it did, whether it changed fundamentally what it was doing from the initial notice of proposed rulemaking towards the final rules to address all those many evolutions that you referenced, Michael. So was Senator Obama wrong? Why shouldn't the FCC have done much the same thing here?
Well, again, I think you have to go back, I think, all the way to the Powell deregulatory proceedings, that these are essentially the progeny of what was started 10 years ago. So this in some ways, this has happened, right? So Kevin Martin had a number of proceedings on this, including public hearings, 3 or 4 public hearings at different places, and Chairman Janikowski had rulemakings on this, and now we have this final rulemaking, at least for now, and we've had intervening court cases. So I don't think you can look at just the last 7 months and say, this is the snapshot of how the FCC operated
But
here.
you're a lawyer. I mean, you deal with administrative law. The whole point is you
When
put
he
out
says
what you're
that,
going to
he means it
do,
as a compliment.
you get public comment on it, and then you either do that, or if you change your mind, you put out a notice of proposed rulemaking, and you get public comment on that, so that the docket actually reflects what you're going to do. And as Michael described earlier, the chairman, his proposal evolved significantly, many times and in many ways from May. Back in May, he specifically said interconnection would be a matter for a different proceeding. Title II, forbearance, reclassification of wireless, all those issues were, if they were addressed at all in the main NPRM, they were only touched on very briefly.
Well, that's what the FCC is going to have to defend itself. I mean, there's 2 pieces here. One is certainly the FCC as a policy matter can change its mind, and that's settled law, and they as long as they explain themselves under the Fox case, they're fine. Within a docket, within a rulemaking, as long as the final outcome is a logical outgrowth of what's been initially proposed, courts have upheld the FCC actually doing something different as the final rule than what was proposed. The question for the court will be, are the final rules a logical outgrowth of what was in the NPRM? And I expect the Rule and Order will address that.
So Jeff, because Markham and Barbara can't comment on this because they represent companies that are involved in this, you don't have that problem. You can opine and always do. So what do you think? Is the FCC going to lose on process grounds here?
Oh, what I was going to say, partly answering that is, in some ways these questions are sort of interesting, and it's interesting to think about the FCC and how it operates, but they don't matter, except to the extent that not building a sufficient record can be a problem in adjudication. The idea that maybe they were responding more than they should have to the president, or whether they made certain things publicly available or not, whether they made it publicly available or not, for example, is never going to be dispositive in court. I would prefer that they had, but now that's, who cares now, right? But the question you asked is the relevant one: is are there process defects that could actually cause them problems when this comes before the court? And honestly, given the extent to which the Verizon court accepted the vicious cycle theory, which had zero evidence to support it, it was a cobbled together cockamamie sort of idea, and represented both, I think, the FCC and subsequently the court, giving enormous deference to try to find support in the record for what the FCC wanted to do under 706. I suspect that we're most likely to find the same result here, even though personally I think that the record has absolutely nothing to support what I believe the rules must look like.
Barbara?
There are other process problems, I would say, in addition to claims of notice violations. And that is, the FCC has a statutory obligation when it puts out a notice of proposed rulemaking to do what's called an initial regulatory flexibility analysis. And that is for the protection of small entities. And they're supposed to, at the time the NPRM goes out, talk about the impact of their proposals on small entities and any proposals contained within the NPRM to address these problems, which would be disproportionately burdening entities who are least capable of bearing regulatory burdens. The FCC, many commenters pointed out, did not follow the Regulatory Flexibility Act. It had an inadequate initial regulatory flexibility analysis, and we'll see how they do in the order. But so there are many types of process defects that can upend a regulatory action coming out of an administrative agency. Notice is one, failure to follow the Regulatory Flexibility Act is another.
Would it be sufficient if they do it in the order? You suggested that they're technically required to do it with the NPRM. If they do it sufficiently in the order, will that?
That's a fine point of administrative law. If I were a judge and the order itself contains sufficient relief for small entities, I might overlook the initial failure.
But from what we heard from the commissioners earlier, it doesn't sound like that's going to happen. As far as Wheeler was asked about this, and yesterday specifically he was asked what relief is given to small entities, and the only example that was offered was that some of the transparency requirements were going to be lighter for entities with fewer than 100,000 subscribers. That seems to be the only relief given.
Appears so.
So, but Barbara, let's connect this to the real world, because this isn't just a matter of administrative law. The whole point here is what Senator Obama was getting at back in 2007. It's sound decision making based on evidence. And your example about Regulatory Flexibility Act is about the small companies that you represent. So could you speak to the concerns of your members?
The American Cable Association has about 840 small independent cable operators, municipal providers, some rural telcos, vast diversity in the membership, all of whom provide broadband internet access, video. Many do triple play, voice. And we put evidence into the record that we thought was pretty convincing that these smaller ISPs lack the incentive and certainly the ability to harm internet openness, particularly, I think, Geoffrey called, I thought you said the vicious cycle.
Oh, he did.
That was virtuous,
well,
as the court and the commission would have it.
I recharacterized it appropriately.
If you accept this theory, and the commission has and the DC Circuit has, that innovation at the edge of the internet will spark demand for service, and that will spark demand for deployment, and investment will follow, and it'll go on and on and on. There is no way, we put into the record, that these small entities could disrupt this virtuous cycle because they simply represent too few eyeballs to matter to the larger internet edge providers. And for the startups, we believe they're far more interested in what Comcast, Verizon, AT&T, and Time Warner are doing in terms of network management practices than they are concerned about what a 15,000 subscriber, municipal a broadband provider is doing. And so there was no evidence of harm. And if the decision was indeed data-driven, as the FCC often claims its decisions are, then we think that should be taken into account in shaping the final rules.
So I want to ask for reactions here, but
Yeah.
please, but just one more question, Barbara. Cedar Falls, Iowa, that's the municipal broadband network that President Obama chose to visit for his big speech about Muni Broadband. They were leading the charge in expressing their concerns about Title II.
Well, they were one of many ACA municipal members who voiced concern to the commission. And in fact, we went in with a representative from Cedar Falls, and they are very concerned that they're going to be subject to a new form of regulation under Title II, which is going to subject all of their terms of service to a just and reasonable standard that's never been applied to them before, among other burdens that would come out of this. And I guess Berin made a good point. In the real world, some of these providers have 4 employees, they've got 15 employees, the same employee's got to troubleshoot breaks in the line, does their regulatory compliance, and now they have to learn what it means to be a regulated common carrier. And this is a concern, and we believe it will be very burdensome.
So reactions?
Yeah, it just sounds to me from everything Barbara said that she and the ACA got, in a practical sense, got everything they asked for. Because I think what gets lost in this discussion a lot is this order is almost entirely prophylactic, right? It will have virtually no impact on the internet at all. I mean, for example, there's a story on the front page of the business section, I guess in the New York Times today, about the Netherlands, right? They enacted a similar strict net neutrality set of rules a few years ago, and they said, what's changed? Nothing. Because in effect, we're not very much aware that there's blocking, throttling, or paid prioritization going on, including by, ACA members. And so, and if they have no leverage to do that, she said, they have no leverage to get away with blocking, throttling, or paid prioritization. Well, then great. If I'm at the FCC, I'm saying, well, then, you're not affected. This is just in case you develop that leverage or you decide you want to try to do that. You can't. The one thing that would impact them is the transparency rules, the burdens. And from what we understand, the small ISPs are getting some help in that respect, both in terms of apparently delay and also in terms of a safe harbor, simplified safe harbor reporting system, so that they, at least that's what the WISPs are saying on their listserv, that will make it easy and more certain, so they know, okay, we fill out this thing online and then we know we're done and we don't have to worry about the uncertainty.
I think so whether their ACA is able to, if they decide to challenge the rules and are successful, the theory of the virtuous circle is already affirmed by the DC Circuit. They said the FCC had justified the theory and affirmed that.
Justified it to sufficient to meet a very low bar deferential review.
But
it doesn't mean it's actually economically true.
So, and they said that the FCC doesn't have to engage in a market power analysis. It seems like the FCC will again rely on the terminating access monopoly theory rather than a market power analysis.
And can you explain that? Remember, we have a live audience on C-SPAN here.
So
may not be familiar with the terminating access monopoly theory.
Yeah, so one of the things that the FCC did in the 2010 order was say we don't have to engage in a market power analysis to determine whether rules are necessary, because every ISP in and of itself is a monopoly with regard to each user. So if you are an edge company and you want to get to my home, to Markham Erickson's home, you're going to have to deal with Verizon and only Verizon. There's no other provider that provides ISP service, broadband internet access service, to my home. And the DC Circuit said that they upheld that theory. So then the question, I think, for ACA is, in this rulemaking, does the addition of Title II add something new that creates a new harm to the smaller members that the FCC should have dealt with? The two answers are, one, whether the rulemaking deals with it in some way, and I think we heard yesterday that it's going to try to do that. I think, secondly, the FCC is likely to say that unless they go beyond the rules themselves as they describe them, not the jurisdictional theory of common carriage, that there is no harm to the providers because they're not engaging in the different activities that Michael mentioned, and Barbara, you're saying that they can't. If the FCC were to go beyond that, then I think the ACA would have an as-applied challenge to the application of something that wasn't in that goes beyond the no blocking and the no paid prioritization, all the other rules that are delineated and that Barbara's saying her members don't do. So I think it's challenging for ACA to try to if the FCC has done this. I think, though, what protects their members is the as-applied piece. If a future FCC were to try to go beyond the rules themselves.
Jeff, a lot was said there. Let me just ask you first about the terminating access monopoly. Is that a thing?
What do you mean, is it a thing?
Is it a real thing? I mean,
no.
Is that actually something that we should be concerned about? Do economists believe in that? Okay. You run the International Center for Law and
There
Economics.
are some who do. Most would point out that it's mostly a fallacy along the lines of the famous Kodak antitrust case, which basically said Kodak had a monopoly over aftermarket products sold to service Kodak copiers. By that same logic, Apple has an absolute monopoly over any app developer who wants to sell its apps on the iPhone. Netflix has in this case, let's call it an originating monopoly over House of Cards and any other content that it produces that others can't otherwise have access to or distribute on their own. And there's about 1 billion other examples like this. It either is something that exists but essentially means nothing because it arises in a near infinite number of instances in the economy, or it is simply a canard. And for it to matter, of course, it actually has to have some sort of economic consequence, right? I mean, it does actually have to be, as a logical matter. I'm not saying that the court has to accept this. The court accepts a lot of crazy things. But as a logical matter, it would actually have to be that the so-called terminating monopoly does, in fact, confer some kind of power. You don't have to call it market power, but it does have to confer some kind of ability to exploit or do something that the rules are intended to correct. But if you don't actually have market power, if indeed there are competitors, it's really hard to see that actually happening. And of course, by the way, we can't forget that we're also dealing with with both sides here, right? The commission made very clear that they're regulating not just the retail access, but also the edge provider access market here the same way. And I would argue that even more clearly, there's no terminating access monopoly from the perspective of Google, for example.
I have two points. I'm not going to talk about the economic theory of a terminating monopoly, but we put evidence into the record that a lot of ACA members face competition. One of the members we went in with had 20 to 30% annualized churn rate. There are options, so it's not that you get from one provider, and if they do something, you have absolutely no choice in every market in America. But the other more important point is I think Michael and Markham were conflating two different things. ACA was not objecting to the net neutrality behavioral rules of no blocking, no throttling, and no paid prioritization. Their members don't do these things, and the rules were not seen as unduly burdensome. What we were objecting to is the collateral damage of having, we now know, 21 provisions of Title II unrelated to protecting the open internet applied to their services and their practices. Every rate, term, condition, and practice in connection with the provision of a common carrier service now subject to a just and reasonable standard. It's not that we think the members are violating this, it's that who knows, because what we learned yesterday is that the FCC will just look at the facts and apply the standard on a case-by-case basis. You've introduced a high level of uncertainty where everybody has to go back and look at everything they're doing, all their communications with their consumers, and test it under a new standard. And they're going to probably need legal advice.
Can I just, and I wanted to ask Michael, I guess, just to talk a little bit more about the idea that there's, I can't recall whether you, and maybe Markham, you may have elaborated to make this point, whether you were making a legal argument, a jurisdictional or authority argument, or an economic logic argument. But I recall you saying that because these are prophylactic rules, they don't have any effect, for example, on Barbara's members. I'm certain that that's not true for reasons she just suggested from an economic perspective. I'm also not sure, though, whether that would make a difference from a legal perspective, even with respect to a facial challenge here, not an as-applied challenge. And so I'm just wondering if you could elaborate on that. I'm sorry, I can't remember which of you made that point.
I think I probably made that point, but I think that will be the issue for a fact finder or an appellate court to look at whether there is sufficient ex ante harm to merit overturning some part of the rule and order. I think it's a difficult case to make. I think it's more likely an as-applied challenge that would come up if they were applied in a way that were to harm some of Barbara's
But you,
members.
but you think that the justification, the justification for the rules, in part because they only apply prophylactically and don't have this sort of immediate curtailment of activity, as I think you allege, that the existing justifications from the Verizon case and the Comcast case are sufficient to justify that, even though now we're talking about Title II and presumably somewhat different rules. We also have the catch-all rule. I mean, it's not clear that even if that were true with respect to those earlier cases, that it would be true here, again, just because it may be the case that there aren't explicit prescriptions that will apply the instant the rule goes into effect.
Well, we'll have to see the rule and order, obviously, to be part of that. But Verizon was challenged in their earlier successful appeal of the 2010 rules in that their public comments were, we don't engage in this behavior, and they sort of had to moderate that and say, look, we are intending to engage in certain kind of behavior that would be prohibited about the rules, but for this, we would explore it. And so, the court there was no stay in that situation because you didn't have the immediate threat of harm. Whether there's an immediate threat of harm like that will be something that...
And the court, if I could just add it quickly, because it's an important point, I think, and the court agreed as well, right, that an ISP like Verizon has both the ability and the motive to engage in those behaviors that they said they would like the option to do, although they weren't currently doing it. In other words, blocking, slowing traffic, paid prioritization. The court said they had both agreed with the FCC that the FCC had made the case. They had the ability and the motive, and obviously, there's actual tangible instances, AT&T blocking FaceTime and so on, that you can point out. And so I don't think that's going to be a problem because then it just becomes a question of what authority is legitimate to address the potential harm. And and the court said, well, no, 706 wasn't the right authority. So now they're coming back with Title II based on what seems to be almost a common sense. I mean, this is one the general public could almost, probably understand that when you look at the definition of a telecommunication service, offered to the public, directly to the public for a fee and so on. I mean, it looks just like it's just like a telephone service, except it does more.
Well, that's an important point. It does more.
Right.
And
So we'll unpack that, and let's come back to that in a moment, Barbara. But two issues here. So first, just to be really precise, the court didn't agree on merits. The court said the FCC had met the very low burden that agencies have to meet when they justify what they're doing. And so, the FCC could have called, blue, green. Could have renamed anything, and according to the approach that courts take to administrative law, the burden for satisfying that initial analysis is almost meaningless. So to say that the courts have blessed that theory doesn't really mean anything, analytically speaking.
Well, so I would take some exception to that. I mean, they do get deference in fact-finding from appellate courts.
And that's what we're
But
talking about
I think
here.
if they said blue is green, that probably wouldn't make the
So
bar.
let's say blue is, well, that's maybe a reclassification.
But remember, in the Brand
if
X
they
case, remember you had 3 Supreme Court justices in the dissent in the Brand X case
Markham.
saying that the FCC did not meet their burden in originally classifying these services as information
So
services.
let's separate, though, the classification decision. My example of blue versus green is a bad example, because you're right, it's more like classification. So let's just say on fact-finding, the idea that the courts have endorsed or put some sort of imprimatur on the FCC's rigor, I think is does not really do justice to how courts actually deal with administrative agencies. So that's just issue number one. Right?
Because now it'll be about this record. It won't be about the last record.
But issue number two, and this is what I want to ask you all about, is, and tell me, this is a yes/no question. Does anybody disagree that we're talking about two very different, admittedly related, but different and distinct issues of net neutrality on the one hand? That's what Barbara was saying, that her members didn't object to, those core rules that Michael is calling prophylactic. And then Title II on the other. So, for example, the last time this went up to the court, the court was only looking at net neutrality rules and the underlying 706 theory, right? The court now has to confront this different set of questions about Title II that raise a different set of policy challenges. Is that fair?
Well, yes, there are 2 issues. I don't think it meaningfully, materially changes the likelihood of whether the FCC is successful or not in appellate review. And again, to say so, I would quibble a little bit with your premise. The original classification under Chairman Martin to classify these as information services was overturned by an appellate court, a Ninth Circuit, that did not accept that en banc, and then it was reaffirmed by the Supreme Court, where 3 Supreme Court justices, led by Justice Scalia, said the FCC absolutely got it wrong. So whether the FCC can now reverse itself and say, no, these are telecommunication services, if your premise is right, that any court's going to accept it, then the FCC shouldn't have any problem.
Well, I was speaking, just to be clear, I was speaking of evidentiary basis for rulemaking, not for reclassification decisions.
But that is based on evidence, right? The evidentiary basis to determine that these were information services was a fact finding, whether that you had an offering, right, that was a information service and not a telecommunication service. The key distinction for the Brand X case was this, whether they were get discretion on this offering.
Okay, so hold on, wait.
But that is
hold on
actually
just a second,
more
because most people who maybe are watching this are not familiar with these 2 arcane distinctions we're talking about. So Barbara, can you just rewind, take us back to 1996, or even the 1970s in Computer 1 and Computer 2, just briefly. What are these 2 different buckets, and what is Markham talking about when he talks about Kevin Martin trying to take it out of one bucket and put it into the other?
And please discuss all opinions and dissents.
In less than 1 minute.
Okay, fine. So there's telephone service, and then there's telephone service plus something else. And in the old days, the Commission called them basic and enhanced, and treated basic service as a Title II common carrier service, and enhanced, which involved computer processing, something else, unregulated under Title II. Not to go too far into history, that held up for a long time. Some people argue Congress essentially codified that approach in the Telecommunications Act of 1996, and it created 3 categories, all new to the Act, to the Communications Act of 1934. It created telecommunications, which is sort of pure transmission, telecommunications service, which is providing pure transmission in a certain way to the public for a fee, and information service, which tracked pretty closely to the FCC's old enhanced service definition, and that was offering the capability to manipulate data and transform it and some other things. So those were the definitions that the Commission had at its disposal when it had the question before it, what is the cable modem service? There's one thing I'd like to correct. The FCC was not the first entity to decide how to classify the cable modem service. That honor was held by a federal district court in Portland, Oregon, in a franchising matter, and the court said, "Nah, this is a telecom service." And what the FCC then did is to say, wait a minute, I'm the expert agency. It's a matter for me to decide what this service is. And it started an inquiry in 2001. And at the conclusion of the inquiry, it issued a declaratory ruling. And it said, no, in our expert opinion, the cable modem service, which was the first broadband internet service to get classified, is an information service because what is offered to the public is more than pure transmission. It's a capability to retrieve data, manipulate data, send data back in a different form. It fits the statutory definition. When that case was appealed, it happened to land in the Ninth Circuit, which I think thought that the Portland decision was a better precedent in the circuit. I might have gotten this a little bit wrong, but I'm closer than you think. And then the Ninth Circuit decision in Brand X, that went up to the Supreme Court. Randy could correct me if I'm wrong here. And so what we had was a rather odd posture where the commission was correcting a federal court ruling, and ultimately the Supreme Court looked at this whole mess and said, that's the expert agency. They've made a reasoned decision here, given the factual characteristics of the service, statutory definitions. We'll uphold it on a split vote.
Okay, so that was the FCC deciding that broadband was not a Title II service, right? And then so people today point to that and say, well, that means the FCC gets deference on changing its mind and on saying, well, maybe it is a Title II service after all. So is that a fair summary of your view, Markham?
Well, what I'd say is, just as they could engage in the original classification, they can change their mind. They get the same exact deference. They just have to make sure that they explain why they're changing their mind, and that's really settled law. And assuming that the rule and order account for that, I don't think that the fact that they've reclassified is going to present a big legal problem. I think it's probably easily
remember
affirmed.
too, that the burden, right? The burden is that the agency acted, that this is a reasonable outcome given the agency's expertise, and so I think Markham had a very important point that in Brand X, the Supreme Court reinforced the idea of discretion to the expert agency. And even there you had 3 justices. 5 justices said, look, it's reasonable enough. They're the expert agency. And 3 said, no, this is crazy, they're wrong. They're just doing this for political reasons or whatever. So now it flips around the other way. It's not that 5 justices need to decide that they're correct. They just need to decide, well, this is reasonable given, their expertise as the communications agency.
So that is important, though, that the place where the reclassification decision is weakest, it seems to me, is in the sort of Chevron step 2, right? The reasonableness or sometimes arbitrary and capricious, I think generally a reasonableness sort of test. And here I think the problem they run into is or the biggest problem they run into is with the fact that they're actually forbearing from many parts of the statute at the same time that they're saying, essentially, they're required to say it's necessary for us to use Title II in order to appropriately regulate here. But that's impossible to say while they're simultaneously saying it's unnecessary for us to use many of the provisions here.
That's totally wrong.
It's not
the path that Congress laid that path down clearly for them. The commission now is following the most recent, some of the most recent actions that Congress did on this, right, was when mobile telephony came along, and Congress said, we don't want mobile phones to be regulated like plain old telephone system like traditional wireline phones. So what we're going to do in Title III, which is where mobile gets regulated, we're going to say that mobile phones are there. It's a telecommunications service, but the commission has the authority to forbear from everything but 201, 202, and 208. In other words, from
Yeah, but
the
Congress
most
doesn't-
basic, just and reasonable provisions. And so Congress laid out the modern Title II approach that the chairman and the FCC apparently is now adopting, but extending more broadly to broadband.
The problem is here in Section 10, in order to forbear, it has to be that, what's the exact language, that the provisions are not necessary to...
competition.
Yeah.
You have to make a public interest finding.
Right. About the necessariness of the provisions. But if you do if you instantaneously both reclassify and forbear, you have a very hard time saying that the Title II isn't necessary while you're appealing to the Section 10 requirement that you say that these provisions are unnecessary.
Well,
But
I
Barbara,
assume that the commission is working out how to
I'm sure. I'm
address
saying there's a weakness here.
Until we see the order, it's impossible to say. But this would not just go up under Chevron. There is the Fox versus FCC decision, which sets a standard for agencies changing their minds. And the standard is not that it's harder to change your mind to make the decision in the first place. It's that if your initial decision was based on facts and your new decision is based on facts to the contrary, you have a higher burden to explain how you arrived at your new decision. And there's another part, which are reliance interests. There's a great deal of reliance interest in the information service classification, whether it was right or wrong at the time. People relied on that, they invested, and so now you have a totally different regulatory regime that's going to be imposed. And going back to the initial question, how easy is this going to be to survive on appeal of the reclassification decision itself? I'll just go back to something I wrote at PFF right before I left, and I said it's no slam dunk. There are a lot of steps that have to be met, and each one of them has to be met, and it's not going to be that easy.
There's one other case. You talked about Chevron. That's deference for agencies. Fox is explaining change views. And then last year, the Supreme Court decided a case in Utility Air Regulatory Group versus EPA, where the EPA had tried to modernize and tailor the Clean Air Act by deciding that carbon emissions were a pollutant, something that Congress pretty clearly did not intend back in the 1970s. But that's what the EPA was going to use to regulate greenhouse gases and to bring down U.S. carbon emissions. And the Supreme Court said, on basic separation of powers grounds, that's a decision that has to be made by Congress. The agency can't rewrite, tailor, modernize its statute to suit its whims. And yet the chairman has used exactly the same language in talking about tailoring and modernizing the Communications Act to have a new Title II, not the old Title II that we've expressed concern about, the one that involves price controls and broadband taxes and so on, but something light and easy to deal with. So isn't that a new new legal hurdle for the FCC to have to jump through in court?
No. I just explained this before, and I think the chairman used it as an example yesterday and previously, is that he said, when he was the chief lobbyist for the wireless industry, they sought this light touch Title II regulation, which Congress had laid out for the FCC to do, in order to forbear from a whole wide range of things that traditionally had applied in utility regulation to telephone systems, for example. And he said that the industry sought that, it's worked great. So he said, I think this is. So he's just characterizing what they're doing now for broadband internet access as being akin to the light touch Title II that was adopted for mobile telephone regulation, something that Congress had laid out for the commission to do. And so it's just whatever label he puts on it doesn't change the reality that every component of what the commission apparently is going to do is right there in the act. It's just a question of how they're piecing it together, and I don't see any reason they can't pick and choose between the pieces that Congress gives them, particularly when Congress directed them for new modern services like mobile telephones to use this sort of light touch approach.
We're at a disadvantage. We're operating without the order and the rule, and that's going to be the critical
Our
piece.
apologies about that.
And so
Clearly our fault.
We'll have to, notwithstanding your efforts to the contrary, we'll have to reconvene, and once we have that, to make a more informed decision. But I do think, given the history here and how we got to this place initially, that if the FCC crosses their T's and dots their I's, I do think they're easily affirmed on the classification to Title II. I don't think it's that hard for them.
I do think UARG presents a serious potential threat, and it's worth looking at if you haven't. And in particular, Gus Hurwitz has written about this recently and is writing more about it as well. It's not the slam dunk that you suggest. It doesn't mean it's not a hurdle they can't get over, but it's a real hurdle, and it wasn't there before last year.
So Congress wasn't thinking, I understand that Congress wasn't thinking CO2 was pollution, back then, but were you saying that they weren't thinking that broadband internet access is a communication service, or potentially a telecommunication service?
It's more about like, right. It's more about rewriting the nature of the act. So essentially, the problem is that effectively the FCC is creating a wholly new Title II and using forbearance in a way that is pretty dramatically different from what forbearance was intended originally to be used for. Here it's being used to regulate an industry and then to carve out a new approach to broadband that's never been created by Congress. What we're embarking on is a fundamentally different Title II from the one that's existed in the past. That is essentially the argument.
One thing that I felt was interesting in the docket leading up to the rule was the Cable Association, Chairman Powell's association, was essentially arguing reclassify but forbear from everything, forbear from every provision of Title II, and just create the rules out of ether. Mm-hmm. I always thought that was a riskier argument. I understand why they made that, but that was the industry's position. Just reclassify but forbear from every provision of Title II, which I thought, from an administrative law perspective, is troubling, right? Because you have no statutory hook at all at that point to challenge that the rule has gone beyond the statute, right? You're just operating it out of nothing. But I did find that an incredibly interesting filing.
I think it would be absurd.
Okay, so just to wrap up this legal discussion, Michael, you mentioned the Dutch law earlier. I'm not an expert in Dutch law. Belgian law, yes, but my understanding is that the Dutch law was a net neutrality law. It said, here's what the rules are specifically, and it authorized their regulator to enforce them. So that seems to me to be very different from what's going on here right now, because that's not invoking Title II and then trying to winnow it down into the basis for prophylactic net neutrality rules. What the Dutch experience is like, if anything, if you're going to point to that example, would be like what Republicans have proposed in Congress, which is here are narrow rules that the regulator would be authorized to enforce without any of the baggage of Title II, without any of these questions about will the FCC win, is it going to forbear from enough, is it going to use the sections that it is not forbearing from for other purposes. So again, I come back to my question, aren't these two very just different things of doing Title II through some narrow grant of authority, which Congress could provide, versus invoking Title II and hoping that it all works?
Yeah, but see, I don't know Dutch law, right? But here's the problem: is probably the Dutch do not have a Title II, so Title II is the problem here. If you look at it from the other way.
I agree with that. Title II is the problem.
No, the existence of Title II, because as the Verizon court found, since Congress created Title II to regulate common carriers, you can't regulate common carriers outside of Title II. If the Dutch
unless Congress acts.
Yeah, and if the Dutch don't have a Title II, if they can simply just decree whatever the regulatory regime will be, then that's
But right across the street, there's a whole bunch of people whose job is to write laws, right? And Republicans, no, seriously, Republicans have offered a solution on net neutrality.
They should pass it.
Okay, so you would support a legislative solution that would avoid the need for Title II?
Potentially.
Okay,
if substantively it's equivalent.
Well, so
But
why?
this is what I'm curious about. I think that I was about to call you unreasonable, so let me rephrase that. I think that most of us would probably agree that the appeal to Title II, by the Commission at least, there are activists out there who want Title II and more and have been pushing in this direction for a long time. But for those of us who are lawyers who may be actually trying to get it right rather than get it as far to the one side as they can, I think we can all agree that the appeal to Title II is a relic of the Verizon case and the cases that came before. It is the FCC trying to find authority to do something, and it's cobbling it together wherever it can. I mean, one of the reasons why we're even discussing whether there's whether the reclassification is a slam dunk is because, well, it's not a slam dunk. The whole thing is it really is cobbling together. It is looking in this massive act that, parts of which go back all the way to 1934, and trying to say, here's what we want to do. They said 706 wasn't enough to do it. Well, they said the policy statement we couldn't do. Now then they said 706 wasn't enough to do it. Look, here's something else. We're going to try this, and this, this might very well work. I would hate to think that anyone sort of sensible out there thinks that we absolutely should do Title II because we want these rules and we want them under Title II. I think most people think, I disagree with them, we want these rules, let's find the authority that lets us do it. And if that's really the world that we're in, then we are precisely in the situation that Berin describes. Congress should be passing a law that authorizes precisely this. If Congress really thinks we should have net neutrality rules, we should have the statutory authority to do it rather than trying to find it in the mouse holes of the Communications Act. I mean, I just think that I understand the defense of Title II. Again, by the activists, they want Title II and they want all of it. And I understand the defense of Title II because it does get you this thing that you want, this net neutrality regulation.
If you win in court.
But does anybody really want Title II, in the absence of its necessity in the absence of needing to appeal to it to get the authority to enact net neutrality rules? I mean, look, everyone, you can't say I want Title II, but I also want to forbear from all of it except the parts that basically allow me to do the net neutrality rules for what I really wanted to do in the first place.
Simpler.
Mine isn't a question. It was a diatribe.
Well, that was a rhetorical question, but let me make it an actual question. So right now there are two bills floating around in Congress. The Doris Matsui-Leahy Democrat bill authorizes net neutrality rules, and the Republican Upton-Thune bill authorizes net neutrality rules, but takes off the table Title II. So do you have a problem with taking Title II off the table for broadband if you get net neutrality rules?
I think the point I was making was just that if you believe that broadband internet access is a common carrier service, the only way you can regulate it appropriately, in other words, the only way you can have non-discrimination requirements under the current law is within Title II.
Right.
I think a lot of people believe, it's becoming fairly widespread. I think, probably a consensus that the Communications Act, the way it's structured with these different titles and silos, is antiquated, and all that needs to be remade at some point. So the point is that, the substance is, and we may not agree if it's a common carrier service, but if you want to regulate it as a common carrier service, right now you have to be in Title II unless Congress acts. If Congress provides substantively the same outcome, I have no problem with that. I can't say that I've, could endorse either of those bills at this point. I haven't studied it.
Can I answer the diatribe in a different way? I mean, there is obviously another way.
Is it a diatribe?
There is another way to look at this, obviously, and that is arguably these were in Title II where they should have been to begin with. Certain parts of the industry were in Title II. The decision was made to deregulate and take these services out of Title II. And at that moment, people said, well, wait a second, you're not going to be able to protect against these harms that most people agree around, no blocking and connection and the Powell policy statement. And commissioners testified that, no, we will be able to still regulate the violations. When Chairman Martin tried to do that, Comcast sued, and they said you can't regulate under that policy statement. So they the FCC then tried using 706. They hadn't used 706 as an affirmative grant of authority beforehand, but the D.C. Circuit invited them to do that. They did. And the D.C. Circuit threw out those decisions, and so now the FCC is coming back full circle to Title II. I think one lesson from this is the ISP should never sue. It gets worse every time. But secondly, to your point, I don't think Title II is a magic elixir. But one way to look at it is people were concerned about this 15 years ago, that there would be not enough authority to do some basic protections. And yes, if Congress were to step in and create something that I think is mostly non-controversial, that creates legal certainty, I don't think anyone would have a problem with that, and maybe that's what eventually Congress will do. They look like they're trying to do that.
Well, one point. The cable industry's broadband internet access service was never regulated under Title II. People seem to forget this, and they were the first providers on a mass scale of broadband internet access at a time when most people had dial-up. So it's not like we're returning to the Garden of Eden of regulation under Title II for these entities. It's a new regime.
Yeah,
period.
no, that's absolutely right.
And it's worth pointing out here, and this is going to be a question, and then we'll turn to the audience. Bill Kennard, Bill Clinton's FCC chairman after the 96 Act, had to figure out what to do with the mess of all these definitions. And he said it would be a mistake to throw cable modem into the morass of Title II, right? He was worried that imposing Title II would discourage investment in broadband. It was just taking off. And it's pretty clear to me, maybe I'm wrong, that I think if Al Gore had won the 2000 election, and let's say Bill Kennard had stayed on as chairman, I don't see Bill Kennard doing anything differently from what the Bush administration did. It was very clear to me that he would have wanted facilities-based competition, and the way to get that was to keep cable modem out of Title II, and to take telephone service out, telephone-provided broadband service out of Title II as well, in order to drive competition. That was the beginning of a bipartisan consensus. Am I wrong?
So I think it's a great point. You're absolutely right that was the decision, and but it's hard to take that out of context, right? Which there was a sense back then that there was going to be a tremendous amount of intermodal competition, which hasn't really developed the way people thought it would. They thought there would be broadband over power lines. You'd have affordable broadband through satellite. You'd have high-speed broadband competing on wireless and wireline. It's clear we haven't seen that kind of intermodal competition come to fruition. Between regulation and competition, I don't think anyone would disagree that competition's always better than regulation. The question is, do you need regulations as a prophylactic in the absence of sufficient competition? This chairman has. Whether Mr. Kennard would reverse based on how things have developed, I think is not easily answerable.
Barbara?
Well, it's true that it's not easily answerable to project what somebody would have done, had they remained in office a bit longer. But part of the backdrop to Chairman Kennard's position was we were in the late 90s. The Commission was struggling to implement the Telecommunications Act of 1996, which was pro-competitive and deregulatory. There was a lot of effort to remove from regulation telecom carriers from regulation that was considered no longer necessary. There was also a lot of new regulation under the 96 Act. I'm not going to sugarcoat that.
Thank you for adding that.
There was a lot of unbundling and all sorts of things that went the other way. But at the time, there was a view that there were traditional common carrier requirements that were just not needed anymore. It's true the Commission was looking ahead to a time of intermodal competition, but I don't think the picture is quite as bleak as Markham has painted. There's a good deal of competition today, but the problem, I think, is that the fear I have, I don't know what's in the order, but that will stop competitive entry in its tracks.
Well, that's certainly what your members have expressed as their concern. I want to take questions from the audience, starting with anybody who hasn't asked a question before. It seems to be the same three people, which is fine. I just asked the same question. But, well, you know what? Okay, we'll give you the same question in honor of Silicon Valley. If you could just wait for the mic. Briefly.
So what advice would you give an entrepreneur as something they can do that is definitively an information service out of reach of the FCC? And so I understand the FCC is not going to regulate where they don't need to regulate, but What would be definitively
Sorry,
outside the
listening?
reach of
That doesn't
the
take it
FCC.
out of the reach of the FCC. Right? There
What
is still 706.
I mean, do we need to wait to see the order and we'll see that thing that's definitively out of reach of the FCC?
Title II, maybe.
And this is maybe a good way for me to ask you all also about the general conduct standard that was discussed on the last panel. So given the general conduct standard and Title II, on top, or in addition to net neutrality, who's safe?
So I would answer this saying, look, edge-based providers, those Silicon Valley companies you're talking about, are safe. This commission has made it clear they're not going to engage in that. I think in regulating that side.
I'm not asking that. So I'm asking any commission
I understand that. So
reading the law would say, oh, well, I can't touch you.
Yeah.
Any commission,
So,
not just the opinion of this commission.
I agree. That was going to be my next point. That when people talk about both sides and regulating both sides, I really think what they're doing is affirming what the D.C. Circuit has said. Judge Silberman made a big point of it, that there's obviously a two-sided market here, right? Broadband internet access is a two-sided market. Most economists would agree with that. They're choosing to regulate one side of the market, and the statute tells them to regulate one side of the market. They're not regulating the second side, and there's no support in the statute to regulate the second side of the market, right? Now, that may be a different policy question than whether you should allow broadband internet access services to charge the other side of the market, which is the net neutrality debate. And reasonable people can disagree whether they should be able to charge that. But recognizing the two sides of the market is different than saying we're going to regulate both sides of the market.
I thought they were regulating both sides. You mean they're not regulating the edge providers directly? They're not.
I don't think they're regulating both sides, but we'll have to see.
Well, at a minimum, they're regulating interconnection, which relates to.
I don't think so that they're regulating both sides of interconnection. They're regulating the broadband internet access service provider side of regulation, the terminating access monopoly side, not
Right.
interconnection.
From what we understand, but again, the order, of course, isn't out yet since the meeting was just yesterday. But from what we understand, just as Markham said, it's the retail side that is the broadband internet access. So there's no classification. If there had been this sender side classification, there may have been some argument along those lines, but this whole idea, I think what's a canard in a way is this notion that
Bill Kennard or the duck?
Oh yeah, no, more the duck, I guess. Is this a red herring? Maybe is a clearer word. Is this notion that now Title II, somehow that Section 201A, for example, could apply to anyone who touches the internet. And, in the first few words of it, it applies only to common carriers. And that's why I kept coming back to this, is that clearly edge providers are not common carriers.
Well, they're not common carriers today, but we have to see how this order is worded, because you could end up being a common carrier tomorrow. I would say at some level, better call Saul, because you'll need legal advice to start a new business, because it's not going to be entirely clear who's in and who's out, and if you're not covered today, could you be covered tomorrow? It's got 317 pages of wordage that must be gone through. I'm sorry, don't have much comfort for you there.
I think especially in a world in which, again, we haven't seen the order and we don't know what a court would do here, but if they're justifying the rules under both 706 and Title II, as they repeatedly claim, they're doing so by making an appeal to this sort of terminating access monopoly. If they are able, as far as the court is concerned, to do this without so narrowly defining telecommunications so that it very clearly might exclude some edge providers. I think in particular edge providers that are offering a communication service, which arguably could be most of them, are absolutely in danger, not just under Title II, but because the telecommunication language doesn't exist under 706, very clearly under 706. And it's not clear to me who can reliably be exempted from this. You could come up with a few edge examples. Someone who I don't know, a weather website or something like that. It puts something up. No, there's no communications. I don't know, but those exceptions be few and far between. Nor do they represent where the internet is going and where it's most relevant. Google is going to have concerns, for example. Amazon. I mean, the big internet providers, I think I doubt are going to find clear shelter from the storm under the order, and depending on what a court does with it, they may not find it there either.
Barbara?
Well, the virtuous circle theory, if it's still part of the rationale of the order, and I have every reason to believe it will be, that posits that anyone who harms internet openness and interrupts this cycle of innovation and demand and investment should be subject to some kind of open internet constraint. And for that reason, ACA argued that the commission should, if it's going to apply to one side of the market behavioral rules, it should apply them to the other side, because this is an interconnected ecosystem, and it would be market distorting to only regulate one player in this environment. And there are actual examples of video edge providers blocking access to small ISP customers, which we brought to the Commission's attention and said, there are as many examples of this as you have for ISPs blocking edge providers, and you should take this into account and adjust your rules to cover it. And obviously we didn't get any take on that in the initial order, but the argument is perfectly valid. And these are communication services.
Well, before Randy asks his question, I'm just going to share with you, Jeff Pulver, who fought for a long time to get the FCC to say that voice over internet service was not a Title II service, said the madness of applying Title II means declaring everything telecom. The Federal Communication Bar Association may not see a problem, but I can attest I have no idea how to judge the difference between IP transmission and IP services for the purposes of my next startup. I will not be able to explain it to investors because the line exists entirely of the mind of whoever happens to be chairman of the FCC at the time, which I think is a pretty good summary of those concerns, in addition to Jeff's concerns that 706 reaches any form of communications. Randy May. Briefly, please.
Thank you, Berin. This is from Mike R. Markham, and it's kind of a segue to what Jeff Pulver just said. I understand all about Chevron, and I understand this deference given, but here's the point and the question. In the Brand X case, when the Supreme Court decided it didn't just accept the case and check a box and say Chevron deference. As you know, what it did was look at the way the service was offered. And remember, offering was kind of at the crux of it. And the discussion on both sides had to do with the integrated nature of broadband access service, the extent to which it was integrated. And of course, they decided that it was an integrated service. Now, I understand they gave some deference, but that basically was a decision that rested on certain facts. In other words, it just wasn't pulled out of the air. So I'm less, I don't think it's nearly the slam dunk that you've portrayed, but just having in mind what I've just said, because neither one of you discussed what I've just said before. How is the commission going to explain the change in the nature of the offering after this long history of distinguishing between information services and telecom services?
Well, as you point out, the Supreme Court basically first has to find that the statute's ambiguous, that it's not clearly spelled out in the statute, which the court has said. And then they said they were giving the FCC deference. They looked at the FCC's rationale. They weren't engaging in a separate fact-finding. They just had to determine whether the fact-finding that the FCC engaged in was reasonable. They even say, and appellate courts have said this on numerous occasions, that looking at what agencies do, it doesn't even have to be the most reasonable interpretation, right, of the fact before it. It just has to be reasonable.
Merely in furtherance of the objectives. I mean, the language is
so
so
I would
deferential.
tend to disagree that I don't think it's going to be a new fact-finding. The FCC will have to justify the change under Fox. The agencies have been able to do that. It's not that difficult to do. I think the FCC, if they cross their T's and dot their I's, I think they're easily affirmed on the reclassification.
Just one quick point, then I'm going to yield the microphone. But on Fox, and this hasn't come up, and understand the premise was the agency can change its mind. But if you look at Fox carefully, you'll see there's a significant discussion about whether the agency, an independent agency, whether the decision has been politicized, how much politics is entered into that. If you look at the opinions, and it could be with President Obama's injection of himself, that there'll be that part of Fox might become important in some appeal.
Thoughts?
Well, it might be.
Maybe.
Some deference under Chevron depends in some part on, appearance of regularity about the process by which a decision was reached. And there are a lot of allegations of tinkering with the process on this one. So it depends. What did the judge have for breakfast this morning? How is this case going to come up? What's the posture? Does it look like a regular run-of-the-mill FCC rulemaking, or does it not?
So we need to wrap up, but I just want to ask each of you briefly, just give me, and we'll go down the panel maybe in this order, just give me your best and worst case scenarios here. What would make you comfortable looking forward, and what would give you concern about how this all plays out? Whether it's losing in court or going off the rails and regulating more than the FCC needs to. Best and worst case scenarios, Michael?
Now, how it plays out, in what respect? In all respects? Or
So, okay,
judicial,
how about this?
congressional?
I'll start, and then you can
right.
do something like what I'm doing, right? So,
Okay.
so for me, best case scenario is Congress creates narrow legislation here and takes Title II and 706 off the table, and this entire fight in the courts is mooted, and we don't have to get into any of the downsides of Title II except for the time it takes to get there. And the worst case scenario is we spend the next 10 years fighting about this in court, and small providers don't enter the market. Investment in communities that are marginal is slowed. People don't see broadband upgrades, and that Title II, the idea that broadband is a monopoly, becomes essentially a self-fulfilling prophecy. So that's mine. Your turn.
So the worst, maybe somewhat in parallel, although disagreeing on the outcome, I suppose the worst case scenario would be that this is fought over in courts for a long time. Congress does nothing, and the courts overturn it. And so after a long uncertainty, we're back to square one. That would be, the worst case. I think the best case would be if it's quickly upheld by the courts, and in parallel, if Congress addresses this as part of a much broader, rewrite that essentially accomplishes the same substantive outcome in the context of a much more sort of streamlined, coherent regulatory framework.
Barbara?
Well, I'll just do it a little differently. I think ultimately we want our laws written by legislative bodies. The problem under the Communications Act of 1934, even as updated in the 1980s and 90s, is that it just doesn't fit today's reality. I've worked on this issue now for, I hate to admit this, almost 19 years, and it feels like Groundhog Day. Every day I get up and we're talking about how to classify the cable modem service. This is not a productive use of society's time, nor mine. So that would be the worst case scenario, that 19 years from now we're still having this discussion.
Asking us to decide whether we should put our faith in the courts or Congress is an interesting question. But I think so I'm hopeful in that we've seen statements from Congress that they agree with net neutrality rules, and that's different because I will say, in my representing different clients, some of the same, in 2009, we had an agreement with ISPs to codify a net neutrality rule, and Congress said no. There was AT&T and NCTA and Verizon, and we were not able to get Congress to agree to codify that. And then the FCC moved ahead with rules, and Verizon challenged those rules, despite the fact that 95% of the marketplace agreed with those rules. So, even just, it's hard to, this is a hard space because you can have one company that challenges the system and they are able to, a big company, slow things down either in courts or in Congress. But I think things have progressed, I will say, in a positive way in those 4 or 5 years where there seems to be a lot more agreement about principles that ought to apply in the space.
I'm going to start with the worst case scenario. The worst case scenario is exactly where we are today, I think, depending, of course, on how interpretation of the rules goes. And inevitably, it will go in the direction of using the rules that were enacted yesterday to do things like regulating what apps mobile providers can put on their phones, regulating prices in exactly the way we talked about before. You don't need to file a tariff for there to be actual price regulation. And intervening in the internet so substantially that it really does curtail not only the investment in the infrastructure, but the investment and innovation that we've seen at the edges. And I think we're there today because I think, as far as I know, if the rule looks like what I think it's going to look like, all of that is possible in the rule as it's written today. The best case scenario is that everyone wakes up and realizes that net neutrality absolutely is a solution in search of a problem, that there's precisely zero economic justification for ex-ante rules that prohibit discrimination and exclusionary behavior and all sorts of things that exist and thrive in every other facet of the economy just because it happens to happen on the internet. And when that happens, if we all wake up and realize this whole thing is a bunch of bunk, and that we have antitrust rules and consumer protection rules that are more than capable of policing the very few and far between potential and sometimes actual problems that arise, we will all be better off. We won't have to talk about this crap anymore. And Barbara, that will satisfy you. And what's more, we're that much farther along toward minimizing the massive role that the FCC plays in the internet and communications ecosystem more broadly. And everyone can agree at some level, right, that the FCC is replete with problems. There's rent seeking on both sides.
But how would you answer Berin's
manipulation.
question then? Would you be okay with the legislation proposed by Congress?
No, I mean, it certainly wouldn't be considered my best case scenario. I'd prefer that. At least then we could stop the stupid discussion. But that would still enshrine. That would still enshrine these net neutrality rules, these prophylactic net neutrality rules that have zero justification in economics or logic.
I should clarify that was really my best case realistic scenario, not my best case scenario. I will say my best case scenario. Larry Lessig, the father of the digital left, the man who really inspired a lot of this movement, he put this all very well back in 2008 when he said it was time to demolish the FCC. That it was a junior varsity Congress that shouldn't be deciding things, that is inevitably captured by the companies that it regulates, and that makes decisions based on politics rather than sound data. That's what Democrats used to say when they complained about the Republican FCC. That's what Barack Obama was getting at and when he was a senator back in 2007. He was right. I think we'd be much better off with a general purpose regulator like the Federal Trade Commission that dealt with these problems.
Or non-problems.
I actually have a worst case scenario. The reclassification decision is upheld and all the forbearance is overturned. That is a worst case.
Then we'll probably get legislation.
That's right.
So it may actually be the best case.
Oh, the best case? It ends. It just ends.
Well, and on that note, it ends.
It ends.
Thank you for coming.
I got my best
We'll
case.
see you at the version of this event after the orders come out, and we can dissect its 317 pages. Thank you.